The initial court hearing after guns are seized. What to expect. Your firearms were seized, and now there's the court hearing that got scheduled within the 14-day period. What's the purpose of this hearing? What needs to happen at this hearing? What's going to be said at this hearing? What do you need to do to keep your guns? What is the state going to do to try to have your guns not be given back to you? The hearing we're talking about, as we've discussed in previous videos, the hearing that has to be set within 14 days is the post-seizure retention hearing. And again, after the judge reviews the sworn affidavit, the judge has to set one of these hearings within 14 days if the judge finds probable cause. And the purpose of this hearing is to basically determine should your firearms be retained or returned to you pending a potential later hearing. So what is the legal standard? Well, the state is the petitioner here. So the state does bear the burden, and they must meet this burden, but it is low at this initial hearing, at this post-seizure retention hearing. They have to establish probable cause to believe that the individual is dangerous. So at later hearings, if your guns were to be retained at this hearing and you didn't get your guns back, you could eventually have another hearing. There is a higher standard at that later hearing, but for the post-seizure retention hearing, all that's required is the state to show probable cause that you might be a dangerous individual. You're going to have rights at these hearings. You have a right to be notified of the hearing, so you do have to know about the hearing. The state just can't say that there's a hearing, or the court can't just set a hearing without telling you. You also have to have the opportunity to be heard, and this includes being able to present evidence and arguments. So you have the right to speak on your behalf. You have the right to present evidence of why the state didn't meet its burden. You have the right to call people, present evidence, things like that. You also have a right to request a continuance for up to 60 days, which is going to generally be liberally granted to allow preparation. So, for example, if you're like, hey, I have multiple people that can maybe be there and testify on my behalf, or I have evidence that's going to show I'm not dangerous, but maybe you can't get it within that 14 days. You could ask the court, hey, can I get a continuance? And generally speaking, the court is going to grant that because those should be granted fairly liberally. The role of evidence here is really important. The police have submitted an affidavit, right? And they're going to use what they said in that affidavit as their evidence. And they're potentially going to give testimony. Maybe the officer is going to give testimony of why he believed that there is probable cause that you were dangerous. But you, on the other hand, can present your own evidence. If you can contradict some of the police's evidence, or if you can show a different side to the story. So what can the outcomes be? Well, the outcomes can either be the state fails to meet its burden, or the state meets its burden. If the state fails to establish probable cause, then the court must order the return of the firearms. It's that simple. State doesn't meet probable cause, you get your firearms back. If probable cause is found, then the guns are going to be held pending a final hearing. So you get another hearing to potentially get your guns back at that later time. The Marc Lopez Law Firm, we're here to answer your questions about red flag laws in the state of Indiana. Don't hesitate to call us at 317-632-3642. And remember, always plead the fifth.